I move to recognize Joel Mayo Almario of the 2nd District of Davao Oriental for his sponsorship speech, Mr. Speaker.
Honorable Joel Almario is recognized.
Thank you, Mr. Speaker. Mr. Speaker, I co-authored the joint resolution number 10 together with Congressman Ronnie Zamora, and I asked this August chamber to support the passage of the committee report on the joint resolution. As a brief backgrounder, Mr. Speaker, we all know that there is a need to extend the validity and period of availability of the fiscal year 2019 appropriations for maintenance and other operating expenses and capital outlays from December 31, 2019 to December 31, 2020. Mr. Speaker, from 2014 to 2017, the MOOE and CO were always good for 2 years or available for release until one fiscal year after the year in which said items were appropriated. MOOE and CO in the 2018 General Appropriations Act had a validity of only 1 year, but was eventually extended to 2 years or until the end of 2019 with the approval of Joint Resolution number 3. And this was also true in 2002 with the approval of Joint Resolution number 1 and in 2013 with the approval of Joint Resolution number 1. In Republic Act number 11260 or the General Appropriations Act of fiscal year 2019, the validity of the MOOE and CO is limited to 1 year or until the end of this year in view of the full migration to the cash-based budget system. Mr. Speaker, it is important to note that the delay in the passage of the 2019 GAA caused tremendous problems for the country. It was signed only on April 15, 2019, or a delay of 4.5 months. As if that deferment was not enough, the May 2019 national and local elections ban on the implementation of infrastructure projects and basic social services further hindered the execution of projects. Soon after that, the typhoon season started, postponing even further the start or implementation of projects. As a result, Mr. Speaker, we still have appropriations that have not been released and allotments issued that have not yet been obligated. As we speak, there are only 3 months left before the end of the year. If the MOOE and CO allotments are not obligated, it will result in the automatic reversion of the unexpended appropriations to the unappropriated surplus of the general fund. This will be, as mentioned earlier by Appropriations Chairman Congressman Ungab, to the detriment of our constituents because the implementation of much-needed projects will be affected. Therefore, Mr. Speaker, I again plead to the August Chamber to support the joint resolution. Thank you, Mr. Speaker.
Majority Leader.
Mr. Speaker, I move to recognize Representative Loren Legarda of the Lone District of Antique. So move, Mr. Speaker.
Honorable Lauren Legarda is recognized.
I'm honored to be standing.
Baka makalimutan ko. Dapat Thank you, Mr. Speaker. Mr. Speaker na pala ho, hindi na Mr. President. Just the Speaker is on the floor. We recognize Speaker Alan Cayetano. I must not forget that I am no longer in the Senate sponsoring the budget of the DBM and the whole, and I am here helping the chairman of the Appropriations Committee. I wish to thank the House Committee on Appropriations for taking the time to consider House Joint Resolution number 9, which seeks to extend the availability of the 2019 appropriations for maintenance and other operating expenses, or MOE, and capital outlay to December 31, 2020. We introduced this amendment of Section 65 of the General Provisions of Republic Act number 11260, the General Appropriations Act of 2019, to respond to the needs of our people. Government agencies have become accustomed to the slow pace of the budget cycle, despite efforts to speed up the implementation of government programs and projects. For this current fiscal year, this perennial problem was compounded by two circumstances. First, the delayed enactment of the budget, signed only last April, and the election period held in the first part of the year. And this prohibited the implementation of infrastructure projects for the duration of that period. While government agencies are expected to have their respective catch-up plans with regard to the delivery of goods and services, the available data indicates that for the first half of the year, only 41.5% of the total allotment of the national government agencies have been obligated, and only 60.4% of this have been disbursed. Of the total annual appropriations, 44.9% have been obligated, and 72.6% of this have been disbursed. There are still appropriations that have not been released and allotment issued that have not been obligated, which will revert to the unappropriated surplus of the general fund after December 31 of this year. However, we are still in need of funds for priority projects as well as for aid and relief activities and maintenance, construction, repair, and rehabilitation of schools, hospitals, roads, bridges, and other essential facilities of the national government. The onslaught of several devastating calamities, the dengue outbreak affecting many provinces, in fact the whole country, the African swine flu that is now plaguing the market, as well as the effects of the southwest monsoon, are only some of the critical problems that we need to immediately address. We do acknowledge that we still have this last quarter of the year for government agencies to still try and implement whatever programs and projects they can. However, I believe it would be more prudent to push for the extension of the availability of funds for the benefit and welfare of our people instead of risking it, which may eventually lead to funds being reverted to the unappropriated surplus of the general fund. Mr. Chair, Congress passed joint resolutions of the same nature in previous years. This was done in year 2002, 2013, and last year. I therefore seek the support of our esteemed colleagues for the approval of this measure. Thank you very much, Mr. Speaker.
Majority Leader.
Mr. Speaker, I move to open the period, to close the period of sponsorship and debate. So moved, Mr.
Is
Speaker.
there any objection? The chair hears none. Motion is approved.
Mr. Speaker, I move to open the period of amendments.
Is there any objection? The chair hears none. Motion is approved.
Mr. Speaker, I move to close. There being none, I move to close the period of committee and individual amendments.
Is there any objection? The chair hears none. Motion is approved.
Mr. Speaker, I move to vote on second reading House Joint Resolution number 19. So moved, Mr. Speaker.
All those in favor, say aye. Aye. Those against, say nay. The ayes have it. House Joint Resolution is approved. On second reading. Majority Leader.
Mr. Speaker, we'd like to greet some guests in the gallery. These are the guests of the Honorable Godofredo Guya of Recoboda Party List. These are Alan Guya Bagay of San Nicolas, Ilocos Norte, Romulo Gabriel, Barangay 2, Lawag City, Ilocos Norte, Tony and Maria Cristina Guzon, Dingras, Ilocos Norte, and Mrs. Edna Guya, Digos City, Davao del Sur.
To the guests of Honorable Guya, welcome to the House of Representatives. Majority Leader,
Mr. Speaker, I move that we resume consideration of House Bill number 78, Committee Report number 5, as contained in the Committee Report number 5, that the Secretary General be directed to read the title of the bill or resolution. So moved, Mr. Speaker.
is there any objection? The Chair hears none. The Secretary General is directed to read the title of the bill.
House Bill number 78, an act providing for the definition of public utility, further amending for the purpose Commonwealth Act number 146, otherwise known as the Public Service Act as amended.
Majority Leader,
Mr. Speaker, the parliamentary status of the bill or resolution is that it is in the period of sponsorship and debate. I move that we recognize the Honorable Sharon Garin to sponsor the said measure. So moved, Mr. Speaker.
Honorable Sharon Garin is recognized.
Thank you, Mr. Speaker.
Mr. Speaker, I move that we recognize the Honorable Stella Luz A. Kimbo of 2nd District of Marikina City.
Honorable
For-
Stella Kimbo is recognized.
Mr. Speaker, will the distinguished sponsor yield to some questions?
Yes, Mr. Speaker.
Mr. Speaker, this is a very important economic bill. The Public Service Act is archaic and requires modernizing. And as the saying goes, the world is now flat. At tulad din ng sinabi ni Honorable Joey Salceda, panahon na para buksan ang ating pintuan para makita ang kagandahan ng ating bahay. Mr. Speaker, our economy will, in general, benefit from increased competition from foreign firms, while at the same time, protect national security. So my questions, Mr. Speaker, are only for purposes of clarification towards reducing possible inconsistencies or increasing clarity in the language of the law. So, again, Mr. Speaker, some observations. The approach of the bill is ingenious. It defines public utilities by enumeration and then allows this list to change with recommendations by the NEDA in consultation with the Philippine Competition Commission.
Thank you very much, Mr. Speaker.
So the effect of the bill or the law is that only 4 public services will be considered public utilities and therefore subject to restrictions on foreign ownership. All other public services can be opened up to foreign investments with some exceptions when national security is a concern. So the nice thing about this bill is that it recognizes that technology can change the dynamics of competition in a market so that at any point in time, public services can become public utilities or public utilities can be downgraded to public services.
That's correct, Mr. Speaker.
And Mr. Speaker, for clarity, there are 4 criteria for public services to qualify as public utilities as enumerated in the bill. 1 is a technology test, meaning the distribution requires a network. 2 are necessity tests. And the last one is a competition test, meaning whether or not the firm is a natural monopoly. Did I correctly summarize the approach?
Yes, Mr. Speaker.
Mr. Speaker. So, with respect to the first criteria, where public utilities must satisfy, which public utilities must satisfy Is it imperative, Mr. Speaker, that the person must directly transmit the commodity through a network? For example, in the case of the NGCP, as the transmission grid for Luzon and Visayas, it actually does not transmit directly to the public, but rather through the distribution utility as well as the retail electricity suppliers. In the case of Meralco, it physically distributes indirectly as well to the customers of your retail electricity suppliers. So I'm wondering, Mr. Speaker, distinguished sponsor, would you consider amending the provision by removing the qualifier directly so that this would allow flexibility in the public utility in choosing business models?
Mr. Speaker, considering that the language of the bill states that what is considered a public utility is distribution of electricity and transmission of electricity. And in the definition of terms, which we will eventually include in the period of amendments, what we don't want to include is the generation. That is clearly what the intent of the bill is. And if the proposal of the Honorable Kimbo would prevent us from including, whether they directly or indirectly, as long as they are not just mere generators of electricity, then the committee can consider the proposal of Honorable Kimbo, Mr. Speaker.
Thank you, Mr. Speaker. And then as an aside, we know that electricity generation is clearly going to fail the natural monopoly test anyway. But if you keep directly as a qualifier here, you would lose your electricity distribution in your list of public utilities, Mr. Speaker.
Well noted, Mr. Speaker. Thank you, Honorable Kimbo.
Mr. Speaker, there has been debate on the floor as to whether electricity distribution should be considered a public utility, considering, as mentioned by the Honorable Zarate last night, that there are several firms actually distributing electricity. So the question arises as to whether or not electricity distribution is a natural monopoly. So, Mr. Speaker, distinguished sponsor, would you agree that the definition of natural monopoly is highly technical? It is based on technology and the cost patterns of a firm as well as the size of market demand, as I have shown here in this slide. So in other words, Mr. Speaker, it requires a technical determination. And so would you agree that using this textbook definition of a natural monopoly, which is a firm whose average and marginal costs decline continuously, such that the scale of activity at which the firm can operate efficiency is so large relative to what the market requires or demands, that only one firm can be accommodated in the market? In other words, if we allow another firm to supply demand, it would be wasteful as far as society is concerned.
Mr. Speaker, I am not an economist, but based on our findings and our research on what is natural monopoly, what happened to the area wherein two legislative franchises were issued in the same area for electricity distribution or transmission, I'm not sure. That is a question of legality. What we are talking here about is natural monopoly. By the nature of it, it is a monopoly, not a legal monopoly per se. That by law, you are only supposed to give it to only one person or one business or entity. Now, what we are talking about natural monopoly is that in an area, for example, for electricity, in an area, there is natural monopoly only when the demand is inelastic. That's based on our legal readings, Madam Economist. There is an inelastic demand and there is a monopoly of supply. That's just probably the layman's way of understanding what is a natural monopoly. But I welcome the description, should there be a technical description, then I welcome it, considering that we have a much respected expert here in terms of economics, Mr. Speaker.
Mr. Speaker, I've been a practicing economist for close to 3 decades. This is the standard definition of a natural monopoly. It requires that the technology is such that average costs decline
When there's competition.
until, and therefore requires a very large scale for the facility to operate efficiently. But having said that,
in fact, I think in natural monopolies, if there is competition, that is not advantageous to the consumers. That's the economic effect.
so I suppose, Mr. Speaker, you would agree that electricity distribution is indeed represented by this kind of a graph.
I think so.
And would you agree, Mr. Speaker, that in the Philippines, because of the IPIRA law, we actually have 2 markets for electricity distribution. The first is the captive market, where a single firm, meaning Meralco, distributes electricity to all its captive customers. The second is the contestable market, where sufficiently large customers can choose a retail electricity supplier, or RES. So it is in the contestable market where there are several firms distributing electricity. Although all of these RESs physically use the distribution system of Meralco. So would you agree, Mr. Speaker, that while the Honorable Zarate was correct in pointing out that there is more than one distributor of electricity, and arguably this fails the naturally monopoly test, it can also be clarified that for the captive market, there is only one distributor of electricity, and hence clearly constitutes a natural monopoly.
That is correct, Mr. Speaker.
And perhaps just to point out as well that the current setup where Meralco is treated as a natural monopoly while RESs are not treated as such is actually faithful to the definition of public utilities as contemplated in the bill. Is that correct, Mr. Speaker?
Yes, Mr. Speaker.
As mentioned yesterday, Mr. Speaker, during the interpellation by the Honorable Rufus Rodriguez, you mentioned that Section 5 of the substitute bill would provide for the power of the President to suspend or prohibit mergers and acquisitions or direct investments that result in direct or indirect control by a foreigner in the interest of national security. Is this correct, Mr. Speaker?
That is correct, Mr. Speaker. In fact, we have already drafted that, and it is, yes, that's correct. That's in Section 5 of the proposed substitute bill.
So, Mr. Speaker, thank you for this. I also think it is wise to have this exception. But my only concern has to do with the jurisdiction of the Philippine Competition Commission. And for transparency, I wish to disclose that I am a former member of the Commission. And under RA 10667, or the Philippine Competition Act, the PCC, or the Philippine Competition Commission, has primary and original jurisdiction over all competition concerns, including mergers and acquisitions. And the doctrine of primary jurisdiction is particularly invoked for PCC because Congress, when it passed the law, recognized that competition matters are highly technical and would therefore require consultation with an agency that would have the capacity to decide on those technical issues. So, Mr. Speaker, just for purposes of clarification, I would like to ask if the phrase relevant government department or administrative agency in this particular provision, which is mandated to make recommendations to the government, especially with respect to possible suspensions or prohibitions of M&As, would include the PCC, Mr. Speaker?
Mr. Speaker, the proposal is the power of the President. I'll just read it, the proposed section. In the interest of national security, the President, after review, evaluation, and recommendation of the relevant government department or administrative agency, may suspend or prohibit any merger, acquisition, transaction, or any investment in a public service that effectively results in the grant of control, whether direct or indirect, to a foreigner or a foreign corporation. And it follows that NEDA shall promulgate the rules and regulations to implement the provision in this section. Now, the basic consideration, when can the President intervene, is in the interest of national security, not when there is against competition, fair competition, which is the primary venue would be the PCC. Although, in my opinion, it would not hinder PCC from recommending to the President that such transaction could be, because unfair competition can also be of national interest. But not everything that is of national interest or national security is unfair competition. So I would venture to say that yes, PCC can also submit to the President and question a transaction or a merger that would involve the transfer of equity to more than 40% to a foreigner or a foreign corporation, Mr. Speaker.
So are you saying, Mr. Speaker, that what is being contemplated in this provision is a kind of motu proprio giving of recommendation?
Mr. Speaker, when crafting this provision, we have reviewed what is done in the European Union as well as in the United States of America. There you have a committee of foreign investments in the US, which is actually could be motu proprio, as well as it could be motu proprio by the committee itself, or it can be the company itself that can get the clearance. But we have decided to leave it to the NEDA to formulate the more appropriate committee for the Philippines, because if we just follow what is done in the US, and they have a different political environment as well as economic environment, so we have left the decision or the design of such procedure to the IRR that will be crafted by NEDA, Mr. Speaker.
Thank you for the clarification, Mr. Speaker. I just wanted to point out this concept of, or this doctrine of primary jurisdiction,
Yes.
so that at least on record there is some clarity as to when or not the PCC can intervene, especially when it comes to an M&A that can potentially be anti-competitive.
Mr. Speaker, I just want to clarify, in this bill, only when there is national security concerns, there is a transfer of the ownership to a foreigner or a foreign corporation, then this can have primary jurisdiction. But in any case that would involve unfair competition, then that would be PCC. In fact, one of the safeguards of this bill in considering the fact that foreigners might, or unwanted foreigners might invest in the Philippines, we have the PCC as one of the safeguards, we have the National Privacy Commission, we have the National Security Council. So all of this are still in place to make sure that the investments in the Philippines are still, despite such investments in the Philippines, we are still protecting the interests of the Filipino people.
Thank you, Mr. Speaker. Clearly, this is a situation where you have a policy objective such as national security, which clearly trumps competition. But the general principle that is applied in cases where you have seemingly conflicting policy objectives is that one should endeavor to attain the more important concern, in this case, national security, but in the least anti-competitive way. So I just wanted to include that in the record.
Yes, Mr. Speaker. In fact, the design in some countries are before you can invest, you have to get clearance from the National Security Council or whatever kind of agency they have. That we have not incorporated here because we wanted to avoid such cases, Mr. Speaker.
And Mr. Speaker, again pertaining to this provision, is there any time frame contemplated for the suspension or prohibition of a transaction that potentially undermines national security? Mr. Speaker, napakahirap naman po na nag-invest na ang isang entity, sila ay nag-acquire ng isa pang entity, at sila ay nagnenegosyo na ng 5 taon, 6 na taon, only to find out later on that such such a transaction would be considered void at one point in the future. So have you considered the possibility of putting some sort of statutory limitation on this?
Mr. Speaker, in our discussions, we have not discussed the issue of the time frame, but I think the NEDA, upon crafting the IRR, can tackle because the expertise should be with NEDA or PCC itself, not I personally believe that it is beyond the scope or the technical capacity of this bill that we are tackling now.
Okay, Mr. Speaker, but I just hope that is something that you'll think about, because this is very important for purposes of reducing uncertainty in the business environment.
Thank you, Mr. Speaker.
Let me move, Mr. Speaker, to the proposed Section 7C, which is on rate regulation. And Mr. Speaker, the proposed approach to rate regulation is that all public utilities will be subjected to rate regulation. But in the case of public services that are not public utilities, rate regulation will apply only when public interest so requires. Is this a correct statement, Mr. Speaker?
Yes, Mr. Speaker.
May I know, Mr. Speaker, why the proposed approach to rate regulation would require the fixing of a maximum rate? I'd like to point out that some sectors in more mature jurisdictions are subject to rate regulation not on the basis of a maximum. For example, the rates of healthcare in the US are subject to a standard which is called URC, or usual, reasonable, and customary. So in this case, usual would refer loosely to an average rather than a maximum. So, Mr. Speaker, won't fixing and determining a maximum rate unduly restrict the options that are available to a regulator? As far as I know, in the original law, there is no mention of the word maximum. There is mention of the mandate to fix and determine a rate, and those rates are enumerated, but there is no qualifier such as maximum, Mr. Speaker.
Mr. Speaker, the original proposal in this bill was actually based on the Meralco case, in which they imposed a 12% rate of return for public services or public utilities. But upon deliberation, in the previous Congress, we have removed the 12% because it was cited that in some industries, even 6% is reasonable. So the committee has decided to do away with specifying the rate of return. And in this case, despite the mention of rate setting here, if the industry is already regulated, then they are not forced to regulate again. We are just giving them the option in which they can set. We are just giving a standard in how to set the rate setting based on the weighted average cost of capital, which was in which maximum was meant to address the decision in which it did not allow the LTFRB to set flexible rates. In that case, flexible pricing of grab, etc., would be on shaky ground. So parang what we are trying to do here is standardize the rate setting para the industry or any kind of investment would be attractive enough for investors because it's a huge capital investment. And at the same time, we are also protecting the interests of the consumers. It's not too high that it's exorbitant in the case of our consumers, and not too low that it will be confiscatory in terms of the investors. But I just want to state again that this is not regulating those that are not regulated already. This is just a standard so that we are at par with whatever international acceptable rate setting systems, methodologies they have. It's why we made sure to specify it here in the proposed bill, Mr. Speaker.
Perhaps, Mr. Speaker, I should ask a few more questions so you can probably think about this word maximum a bit more. For example, will this maximum rate be known to the public service that is being regulated? Is it going to be known to the public? If the maximum rates are fixed and known, won't there be a danger of public services maximizing that rate anyway? And in the case of public services with more than one service provider, won't there be a danger of collusion where service providers can implicitly or explicitly agree to fix prices at the maximum rate precisely designated by the regulator? And again, this is a violation under the Philippine Competition Act. So we don't have to look far to think about examples. Let me give you a very concrete example. The Department of Energy's approach to rate regulation for fuel prices sets a kind of maximum rate. The DOE imposes a formula on all companies using parameters that are constant or the same for all companies. So kasama dyan ang MOPS, kasama dyan ang exchange rate, ang tariffs, ang value-added tax. So it now becomes a kind of maximum. Now the problem here is that the companies end up maximizing that rate anyway. So if they say that allow us to increase our price up to 1 peso, why will they increase their price up to 90 unless, of course, there is vigorous competition in a particular geographic market? So apart from that, companies end up maximizing the rate. The other problem is that oil companies seem to be engaged in tacit collusion or price fixing over this maximum rate, Mr. Speaker.
Mr. Speaker, should the Honorable Kimbo propose to amend and by deleting the word maximum, then this representation is amenable?
Thank you, Mr. Speaker. I will propose individual amendments at the appropriate time, Mr. Speaker. Anyway, just to justify why one can remove the word maximum there. Anyway, Mr. Speaker, the succeeding proviso fairly describes what an appropriate rate should be, invoking important benchmarks such as efficiency, prudence, and reasonableness. All of these words are in that proviso. For example, Section 7C states that the rates must be such as to allow the recovery of prudent and efficient costs and a reasonable rate of return to enable the public service to operate viably. Mr. Speaker.
Yes, Mr. Speaker, those were words actually that were inputted by the different administrative agencies as well that are responsible for the rate setting, Mr. Speaker.
It might be good, Mr. Speaker, to define what operating viably means. So those are the last two words of this proviso on rate regulation. So the idea is to find that rate that would be consistent with the public service operating viably. Ano po ba ang naisip natin? Anong ibig sabihin ng operating viably? And I think, Mr. Speaker, it is important to know what this means. What is the specific price that would be consistent with viable operations? We have to remember, Mr. Speaker, that as soon as this bill becomes a law, the regulator will no longer have to seek prior approval from Congress when it sets a price. So kinakailangan malinaw ang language dito sa section na to, Mr. Speaker. So again, what is a viable price?
Mr. Speaker, the operating viably is actually in reference to the Republic of the Philippines versus Meralco case, in which, as I mentioned, it was mentioned that the reasonable rate of return for rate setting purposes is 12%, and that income taxes are not recoverable expense for rate setting purposes. The point in that decision was that the rate should not be confiscatory, but should meet the required rate of return in the market for investments of similar risk. That is how the decision was made, and that is why we have placed that terminology in the rate setting section, Mr. Speaker. But we do not have any technical description of the terminology, Mr. Speaker.
Mr. Speaker, if I may share some information, in the economics literature, particularly on regulating natural monopolies, when you speak of a viable price, it is the price that is equal to average costs. In other words, unit costs. So that is typically what is construed as what is viable in a natural monopoly.
It's the average cost.
The average cost of producing the service. In other words, take total costs and divide it by the number of units produced. That would be the average cost. So the idea is, if you impose the price that is efficient, ang mangyayari po niyan, malulugi ang natural monopoly. And so, pinapayagan ng regulator na iset ang price sa average cost, bagamat siya ay mas mataas sa efficient price. So my question is that, will this concept of a viable price, which is well known in the economics literature, is that concept also going to be applied to the situation of public services that are not public utilities? So kasama na po dyan ang telcos, kasama na rin dyan ang transport, kasama dyan ang LRT.
Yes, Mr. Speaker. In fact, I think the average cost pricing is what we call the weighted average cost of capital, return on the weighted average cost of capital, which is actually already applied by some of the industries, Mr. Speaker, especially in ERC.
Mr. Speaker, meron po ako nakikitang problema na kung ang average cost ay ginamit na basehan para sa konsepto ng viable operations, para sa dalawang sets na to, ibig sabihin ang public utilities versus ang public services na hindi public utility, baka magkaroon tayo ng problema dun sa pangalawang set. Because, at pinakita ko po yan dyan sa slide na yan, I've made a distinction between a natural monopoly and a standard monopoly, and as you can see, the difference is in the nature of the costs. Ang problema po is that kung meron tayong captured regulator, pwedeng maabuso ang konsepto ng viable price. Pwede niyang payagan umiral ang monopoly price na mas mataas sa efficient price at baka gawin niyang palusot na ito ay ang viable price. Sasabihin niya na yung mataas na presyo ay ang viable price. Dahil yan ay ang presyo para maging isang going concern ang negosyo. So yun po ang fear ko lang kung hindi maliwanag na dapat yata sa aking palagay, we make a distinction between what is the acceptable price in these two different situations, Mr. Speaker. So
Yes, Mr. Speaker, should the Honorable Representative have any recommendations for amendment in the specific provision, then the committee would consider such, Mr. Speaker.
So, Mr. Speaker, just maybe a quick fix, but although, again, I will propose it in the appropriate time, perhaps one can simply make this distinction by adding a few words. For example, to say that the reasonable rate of return should enable the public service to operate efficiently, and in the case of a public utility, to operate viably. And I think those additional few words would already address this concern, something that you can probably consider, Mr. Speaker.
Yes, Mr. Speaker. Thank you very much.
Now, Mr. Speaker, I would like to move on to sections 4, 5, and 6, amending sections 13, 14, 15.
4, 5, and 6.
Yes, Mr. Speaker. So this is on the necessity of franchises for public services. Part of the reason, Mr. Speaker, for why franchises need to be issued is clearly economic in nature. A regulator decides on the number of franchises to issue to limit the number of players in a market, and this is usually to guard against overinvestments and wasteful duplication in natural monopolies. A regulator would also decide on which entities would receive the franchise. So that, Mr. Speaker, both decisions, whether the number of franchises to issue and the identity of the franchise holders, these are precisely for the protection of public interest. For example, the promotion of public safety or the avoidance of public inconveniences, such as traffic or pollution. So would the good sponsor, Mr. Speaker, agree that these are, in fact, the merits of franchise issuance?
One minute. Hinahanap ko yung section sa dali. My apologies, Mr. Speaker. I was just looking for the section. Yes, I agree with the observation of Honorable Kimbo.
And Mr. Speaker, I was actually referring to sections 567 rather than 456.
567.
So, thank you, Mr. Speaker. Would the good sponsor please confirm that the amended section 13 of the substitute bill does not require GOCCs that provide public services to secure franchises from Congress?
No, Mr. Speaker. The GOCC needs to have a franchise or authorization.
Mr. Speaker, I'm looking at section 6 of the substitute bill. Is that something that we can refer to?
Yes.
So, if I may read the relevant phrases, no public service shall operate in the Philippines. Sorry.
Section 15 of the original of PSA. Section 6 in the substitute bill. Is that correct?
Sorry, Mr. Speaker, I would like to refer to section 13, rather, of I would like to refer to section 4 that amends section 13 of the Commonwealth Act number 146. And let me read the relevant phrases here, that provided that public services owned or operated by government entities, etc., shall be regulated by the administrative agency in the same way as privately owned public services, but a franchise, etc., shall not be required of such entities or corporations. So am I correct that this means that the GOCC providing a public service is not required to have a franchise, Mr. Speaker?
Yes, Mr. Speaker. It's the just to correct the franchise is not necessary, but the regulation of it will still be under the regulation of the administrative agency, Mr. Speaker.
But they will not be required to have a franchise, Mr. Speaker. Is that correct?
Yes, Mr. Speaker.
So, Mr. Speaker, what is the rationale for this?
Mr. Speaker, this is the amendment in Section 13, letter A, is the committee has not amended any of the original provisions of the Public Service Act. The only provisions that, the only parts of the Section 13, letter A that we have changed is to update it. Instead of commission, we put administrative. It's more of housekeeping that we have placed. We have decided not to touch on the concepts behind this original section under PSA, Mr. Speaker.
Well, Mr. Speaker, the reason for why I raised this question, well, two things. One is that would this mean that, so as you pointed out earlier, it's the admin, despite not having a franchise, the admin agency will have jurisdiction over this GOCC. Is that correct, Mr. Speaker?
Yes, Mr. Speaker. This was based on this was a 1936 law, and the 17th Congress actually did not touch on this provision, but in this Congress we have touched on it just to clean up the law and update it into, instead of just a certificate of public convenience, instead of issuing a certificates of public convenience, we changed the terminologies to update it to the current times. Now, in fact, the GOCCs with original charters, the franchise are already included in the law creating the GOCCs. It is not based on the franchise given by the Public Service Commission originally, Madam Speaker.
So
It was a different, the GOCC law actually superseded the PSA law, because this is an 83-year-old law. Now, with the GOCC law that created the GOCC, then the franchise should be included in there, and that will be the law that should apply to them, Mr. Speaker.
So, Mr. Speaker, are we saying that it is possible that the franchise governing a GOCC and a franchise governing a privately owned competitor would vary in nature? Is that a possibility, Mr.
Just
Speaker?
to cite an example, the PAGCOR is a GOCC, and it has a franchise because it is in its original charter. Now, I cannot cite any other GOCCs that needs a separate charter or has in its original charter, Mr. Speaker.
So, Mr. Speaker, in this example, supposing hypothetically that PAGCOR would have a competitor 1 kilometer away, privately owned, that private entity would need a franchise.
Yes, Mr. Speaker.
So would it be possible, Mr. Speaker, that their franchises, the terms of those franchises are different?
It is possible, Mr. Speaker.
So, Mr. Speaker, is that a possible concern with respect to competitive neutrality? We don't want a situation where we provide undue competitive advantage to a GOCC. That reduces competitiveness in our environment, which, as we all know, the very reason for why we're standing here is we want to make our business environment more competitive, Mr. Speaker.
Yes, I agree, Mr. Speaker. That could cause such problems, and if the good interpolator has any amendatory provisions, then the committee can consider, Mr. Speaker.
Thank you, Mr. Speaker. I have none at the moment, but I shall try to reflect on it, Mr. Speaker. Now, Section 14 provides a list of exempted activities. So there's mention here in Section 14 that the list of exempted activities are exempt from Section 13A. So may I ask if this exemption refers to the jurisdiction of the agency or to the franchise requirement?
The exemption of warehouses, you mean, Mr. Speaker?
Yes. So if I may, Mr. Speaker, Section 5, which amends Section 14, states the following are exempted from the provisions of Sections 13A, B, and C. And Section 13A actually has two parts. One refers to the jurisdiction of the admin agency, The second refers to the exemption of the GOCC from the franchise requirement. So my question is, which does the exemption refer to? Because if it refers to the franchise requirement, then you are exempting an exemption, which means the listed activities are now required to have a franchise. And if we move further down to Section 15, Section 15 says no public service shall operate in the Philippines without a valid franchise. So I'm saying that there seems to be inconsistencies in the language of those three provisions. So for example, if you apply those three sections to the case of warehouses owned by the NFA, by Section 13, they're exempted from the franchise requirement. By Section 14, they are exempt from that exemption. In other words, they're required to have that franchise. By Section 15, again, the warehouses owned by the NFA are exempted from the franchise requirement. So, Mr. Speaker, would you agree that there is a need to revisit these provisions and harmonize those various sections to reflect a clearer justification and rationale for the issuance of franchises? But please, Mr. Speaker, keeping in mind the importance of competitive neutrality, Mr. Speaker.
Yes, Mr. Speaker, the committee has already considered that because it is inconsistent with there are some errors in the crafting of the said section, and we have already considered the amendment of that, Mr. Speaker.
And on my final topic, this is going to be short, Mr. Speaker. Section 21 specifies the range of penalties, which is 5,000 pesos to 2 million pesos. Mr. Speaker, would you confirm that these figures were determined by applying the applicable inflation rates on the penalties that were specified in the original law?
The proposal is 5,000 to 2 million, as against the original, which was 200 pesos on a daily rate fine. Now, while applying all the inflation rates, CPI, and all that, we would have come up with 5 million pesos. But upon consultation with the administrative agencies and also with NEDA, we have settled with 2 million pesos. That considering that some of the industries are bigger than others or smaller than others, then we have put a minimum and a maximum up to 2 million because, for example, in LTFRB, fining them with 20,000 per day is exorbitant. But for an energy company, 2 million is in fact very viable for them. But we had to consider some of the other industries, hence for the range of 5,000 to 2 million, Mr. Speaker.
Considering, Mr. Speaker, that you have a wide range of public services spanning also a wide range of market structures. For example, you would have the tricycle drivers, which are very small, businesses. Perhaps the 5,000 pesos might seem like a reasonable minimum, but my question is the maximum. Is that potentially too low, considering that the currently prevailing fines for business entities are very high? For example, again, under the Philippine Competition Act, the maximum fine for a second offense for price fixing is 200 million pesos. And in fact, just looking at some cases of the PCC, one firm was fined, I think, about 50 million pesos. So I'm wondering, Mr. Speaker, if you would consider recomputing or reassessing the maximum fines so that this law would be at par with other business-related laws, Mr. Speaker.
Yes, Mr. Speaker. Also considering that we used, by using 12% cumulative interest, we arrived at 5 million. But it was a matter of consultation from the other agencies because for energy, 5 million was not an issue. But for air transport, they go by a daily, by a per passenger rate. Every industry had a different had a different rate set, or well, fine setting method. But what we have to remember is that the 2 million, should they apply the maximum, is a daily rate. And it's a daily rate. Every time they don't operate or they fail to deliver, then they're fined 2 million pesos. And what we don't want to happen also is that we charge, but we have a fine that will cause an increase on the rates as well. But should the good interpolator have any other calculations that she would deem more appropriate, then the committee can consider, Mr. Chairman, Mr. Speaker.
I think, Mr. Speaker, the clarification that it is a daily rate is a relief. I think that's probably going to be a reasonable range. So again, Mr. Speaker, I really think that most economists, including myself, consider this as a big step towards the right direction. Matagal na naming inambisyon ang batas na to. Salamat sa pag-shepherd sa batas na to. I wish, of course, to take a more active role in this very important economic reform and will propose individual amendments at the appropriate time. Thank you, Mr. Speaker, distinguished sponsor.
Thank you very much.
Majority Leader. Majority Leader.
Thank you, Mr. Speaker. Before we call on the next interpolator, we would like to recognize and acknowledge the presence of the following guests of the Honorable Sarah Jane Ilago of Kabataan Party Lists, namely Cesar Carlito R. Baclagon, Mitzi Tan of Youth Advocates for Climate Action in the Philippines or YAKAP Alliance, Ryan Bello of Youth Strike for Climate Philippines, from Laguna, Dennis De Torres, Angel R. Barcenas, Philip Louis Dumagat, Anisha Shabal, and Luz Cañas.
May the guest of Representative Ilago please stand to be recognized. Welcome to the House of Representatives. Majority Leader.
Mr. Speaker, the next House member who wishes to interpolate the sponsor is the gentleman from the 2nd District of Surigao del Norte, the Honorable Robert Ace Barbers, for his interpolation. So moved, Mr. Speaker.
Honorable Ace Barbers is hereby recognized.
Thank you, Mr. Speaker. Thank you, Majority Leader. Will the distinguished sponsor entertain few clarificatory questions from this representation?
Gladly, Mr. Speaker.
Thank you. Distinguished sponsor, I will not belabor much on the constitutional issue of the proposed measure because that has already been extensively discussed and interpellated by my colleagues yesterday and today. But I'd just like to express my conformity to the position that this measure is not only contrary to the intention of the framers of our Constitution, but it will really create a great danger to our national security and self-reliant economy. For instance, take the case, for example, of the telecommunications or telecommunication sites that came out in the papers several weeks ago that were situated or located inside our camps, military camps. If we allow 100% foreign telecommunication companies to locate inside our military camps, isn't this, Mr. Speaker, distinguished sponsor, going to pose a threat to our national security? And will the distinguished sponsor allow that to happen?
Mr. Speaker, the main purpose of this bill is to define public utility. It does not, by defining public utility, by classifying an industry as public utility, does not mean that, does not involve the assessment whether there is a national security issue or not. Now, when we classify a certain industry as a public utility, it is based on certain criteria in which it is stated in the proposed bill just let me cite quickly that the person regularly supplies, and it is of public consequence, there is a natural monopoly and needs to be regulated, it is necessary for the life and occupation of the public, and the person is obligated to provide adequate service to the public on demand. There is no mention of national security there. Now, that is why having it classified as a public utility does not mean that it is of national security issue. In fact, even if you are a public service, it can still mean that you are of a there could be a public security issue. That is why in the proposed amendment of the bill that has been approved by the based on the committee report, we have drafted a substitute bill in which it will include the intervention of the President in cases where there is national security, in which the President can intervene in any, prohibit, suspend any merger or transaction that can, acquisition, transaction, or any investment in a public service. Public service, that includes any public utility, which will effectively result in the grant of control to a foreigner or foreign corporation, Mr. Speaker.
Thank you, Mr.
But
Mr.
I do agree. In cases of national security, we have to be very sensitive and we have to be proactive on that, Mr. Speaker.
Thank you, distinguished sponsor. My question was, will you allow the existence or presence of a telecommunications company inside a military camp? I perfectly understand the intention of the distinguished sponsor in one of the sections or provisions of this proposed bill, that in cases of national emergency, the President takes over. But, Mr. Speaker, distinguished sponsor, the danger is in the definition of the word public utility. In fact, the bill, which is entitled Providing for the Definition of Public Utility, in the body of the bill, Mr. Speaker, distinguished sponsor, if you read it, it is more like a restrictive enumeration of what should be considered as public utility. As a matter of fact, the bill named only two utilities, yung tubig at yung kuryente, ang nabibilang sa public utility kung tawagin, Mr. Speaker. So, ako po ay nababahala na kung ililimitahan lang natin sa dalawang sektor, tubig at kuryente, ang pag-classify sa kanila bilang isang public utility, it now opens the floodgates for foreign ownership in very important industries such as telecommunications industry, transportation industry, which somehow, if controlled by foreign corporations or foreigners, would pose an imminent threat to the national security of the country. Yun po ang aking punto, Mr. Speaker, my distinguished sponsor.
Yes, I agree in some points, Mr. Speaker, but I stand by the fact that the definition, under the definition of what is public utility, in which that definition was based on the transcripts from the CONCOM deliberations, as well as the decisions of the Supreme Court in various cases, telecommunications would not fall under public security. But I agree that in some cases, should there be a tower inside of our bases, then it is a threat to national security, and in which we can always qualify that in cases that there is a threat to national security, the 60-40, if so, or even higher restriction will apply. It will, that is why we have put it in the proposed substitute to the current bill, that in cases there are concerns on national security, then our government can intervene and not allow the transaction to push through, Mr. Speaker. But I would just want to repeat that qualifying classifying a certain industry as a public utility does not mean that there we are allowing that there is no threat to national security there. If you're a public utility, there still could be a threat in national security. If you're just a public service, there could still be a threat to national security. The provision on the intervention of the government will apply to all industries, Mr. Speaker.
Yeah, essentially, Mr. Speaker, distinguished sponsor, the essence of the proposed measure is to define, quote-unquote, limit the public utility into these two very important sectors in our society, the kuryente at yung ating tubig. And because of that, Mr. Speaker, my distinguished sponsor, we are effectively or technically amending the definition as adopted in or contemplated by the framers of our Constitution in the real meaning of public utility. There were also jurisprudences that were issued with respect to the real definition of public utility. And because of this bill, of this proposed measure, Mr. Speaker, distinguished sponsor, we are practically opening the floodgates to making public utility as an open industry for foreign ownership. Kasi nga ho, kapag halimbawa, yung ating for instance, ay transportation sector, dominated, controlled, and operated, for instance, by let's just take for the case, for example, of Beijing Transportation Incorporated. And suddenly, a national emergency happens wherein there is war between these two countries. And a very vital and important sector or industry in our society is controlled by our enemies. What will now happen to us, Mr. Speaker, my distinguished sponsor? So, technically, by in this proposed measure, we are changing the definition of public utility, which I think poses a great danger, Mr. Speaker, my distinguished colleague. Kasi nga, hindi ko po maintindihan na we will go against the intentions of the framers of our Constitution in this definition. Kapag ginawa po natin yan, it's as if we are amending the provision of the Constitution.
Mr. Speaker, there is no intention to change the intention of the meaning of the Constitution. The Constitution merely states public utility in which the Constitution does not define.
Yes, I agree, Mr. Speaker.
Yes, Mr. Speaker. But if we go through the deliberations in the Constitutional Commission, there are industries. In fact, transportation was mentioned in the deliberations in Constitutional Commission. But also other industries were mentioned. Ice plants, and other industries like telecommunications, storage, warehouses were mentioned. Now, that was some of the industries that were mentioned. In fact, now, going through all the decisions of the Supreme Court, some of these industries are not anymore public utilities. They are public services na lang. Which means that what we have to rely on, Mr. Speaker, is not the list of industries that were mentioned during the Constitutional Commission deliberations or the list that was given in any decision. It is the concept behind why they derived those lists. And that idea of how to define public utility is embedded in this proposal. Now, based on those rulings of the Supreme Court and then the deliberations of the Constitutional Commission, at this time, in 2019, the authors of this proposal believe that the transportation or telecommunications is not anymore a public utility because of globalization, the onset of innovation, technological innovation. Now, one basic feature is that it is not a natural monopoly. Hence, but I recognize the concern of my distinguished colleague. We can eliminate the fears of our constituents by addressing the national security concerns that still, should our colleague believe that there is national security, we still maintain the 60-40 in some cases. That could be a proposal, Mr. Speaker.
Thank you, Mr. Speaker, distinguished colleague. In your definition, is it correct to assume, distinguished sponsor, that it is also possible that maybe in the next Congress, they will again change the definition of public utility and then eventually leave us with the definition that the only remaining public utility is the, let's say, for instance, the ice plant.
Yes.
That is possible, Mr. Speaker. Am I correct to assume that, distinguished sponsor?
It is possible. In fact, over the years, there have been changes in the listing. Not only here in the Philippines, but also in jurisdictions outside the Philippines, like in wireless communications in Pennsylvania is not anymore a public utility. In some places, LPG is not anymore a public utility. Here in many cases, ice plants, stevedoring, petroleum, shipyard, cold storage were in fact mentioned in one case in the Supreme Court that they are not anymore public utilities. So it is not a static list. Every like 10 years ago, the list would have been different, and 10 years from now, it could be different again.
Was there any instance, distinguished sponsor, in the jurisprudence or in any case that the public utilities definition was changed, other than those that we understood as contemplated by the framers of our Constitution?
The deliberations in the Constitution Commission, as well as the jurisprudence, are not being consistent.
So
it's a case-to-case basis. That's why we found it fitting to have a definite list list of qualifications in order for a certain industry to qualify as a public utility. It's a case-to-case basis. In one case in the Supreme Court would state something else, and then the next one would have a different ruling. So that is why we have decided to find the fitting definition of what is public utility, Mr. Speaker.
So that makes it more dangerous, Mr. Speaker, distinguished sponsor. Anyway, we go to the effects or the consequences of opening public utility businesses to foreign corporations without equity restriction. Let us take again the case, for example, of transportation, as discussed yesterday by our constitutionalist colleague, Congressman Rufus Rodriguez, where your measure or this proposed measure will technically have the effect of allowing 100% foreign-owned corporation to engage in a transportation business. Am I correct?
Yes, Mr. Speaker.
So if that is the case, if we allow a 100% foreign-owned corporation to engage in transportation, what would then prevent a foreign corporation to engage in, for instance, TODA, yung mga tricycle natin, yung mga maliliit na negosyo where Filipinos are these are part of the daily lives of the Filipinos. Kunyari, yung Association of Tricycle and Padjak drivers in the country all over Visayas or all over Mindanao. What would then prevent that, Mr. Speaker, distinguished sponsor? Because I cannot imagine a local or a national TODA that will be controlled by foreigners.
Yes.
It seems ridiculous, but what is more alarming is that this scenario threatens the existence of our small entrepreneurs. Yung maliit na negosyong yan, baka sila pa ang maging kakompetensya na malalaking mga kumpanya. Hindi ba yan alarming for us? Or shouldn't we be alarmed, Mr. Speaker, distinguished sponsor, if this bill becomes a law?
Mr. Speaker, the threat will probably be more on the bigger companies rather than the small companies, because we already have measures in place or laws in place that prohibit any foreign direct investments. For example, like the Foreign Investments Act, in which there's a $200,000 minimum investment, as well as in the retail trade, in which we are currently under deliberations for liberalization. Still, the limit is still $200,000. And in fact, there are also regulations in terms of immigration. Now, a Chinese tricycle driver cannot work as a tricycle driver in the Philippines, while there are still Filipino tricycle drivers in the Philippines. In fact, any technical or managerial position, probably if there are other Filipinos qualified to do such, then they will not be allowed to work here under a valid visa. So we are the small industries are still protected, Mr. Speaker. I would say that the threat is more in the bigger companies, but then the companies, for example, in sea transportation, in which it badly needs improvement. We have one of the most expensive in the world, and it is costing our consumers, because our agricultural products are 40% higher or 30% higher because of the cost of transportation. We believe that by liberalizing the sea transportation, we will have a more competitive and healthier environment in which our consumers, our constituents will benefit because of the lowering of prices and the improvement of services. But I do believe, the sponsor believes, that the smaller industries will not be threatened by the proposed bill.
Okay, I'm just citing the Padyak and the tricycle or the TODA as a possible investment venture by these foreign corporations. Because if you pull the TODAs all together, it might even be more than $200,000 US in terms of their investments. But following that line, Mr. Speaker, distinguished sponsor, in your explanatory note and in the objectives of the bill, the intention was to open certain industries and businesses not covered in or not stipulated in this measure. Kunyari, dito ho sa ating power generation.
Yes.
Kulang pa ho ba yung power generators na existing sa ating bansa sa ngayon?
Mr. Speaker, in terms of power generation, under the proposal, it will be not a public utility, it will remain as a public service. Also because under EPIRA law, it is considered not as a utility, public utility anymore. And furthermore, the definition of a public utility being a natural monopoly, power generation can be sourced from different kinds of sources. It can be solar or any other kind of energy, as well as you have you can source it from different companies, Mr. Speaker. So it is not a natural monopoly. Hence, it does not qualify under this law as well as under EPIRA, which has been enacted a long time ago, that it is not a public utility, Mr. Speaker.
Am I correct, Mr. Speaker, distinguished sponsor, that power generation is not included in your definition of public utility?
Correct, Mr. Speaker.
So if that is the case, distinguished sponsor, a Chinese or any other foreign corporation can own a power generating company in the country, correct?
Yes,
Tama po
Mr.
ba?
Speaker.
So kung ganun po yan ang mangyayari, if in the event they put up a nuclear power plant in the country, ano bang kailangan nilang gawin? Ano bang mga permiso o permits o dokumento ang kanilang kailangan applyan? At kung sino ang magre-regulate sa kanila? Is it the LGU? Is it the DTI? Is it the BIR? This is quite a serious industry, Mr. Speaker, distinguished sponsor. So I'd like to be educated by
Mr.
the...
Speaker, under the current setting, without this proposal, Chinese can actually invest already because it's not a public utility,
So for instance, dun sa
regardless of the passage of this bill or not.
dun sa controversial na Kaliwa Dam, where a Chinese investor is more than willing to lend us money to put that up, wouldn't that be posing a threat both
I'm
to
not
our
sure what
nationals?
the function is, if it's about water distribution or water supply.
Well, partly, yes, power generation and water supply. I'm just citing, for example, distinguished sponsor, na itong sa tubig naman, no, kagaya nung sa power, ay kung halimbawa, itong isang Chinese corporation, siya ang nagmamay-ari ng ating mga dams. Dams does not just supply water, they can also supply power.
Yes.
So,
Mr. Speaker, the public utility, let's say water, even if it is not considered public utility, it will still be still under regulation, Mr. Speaker. If it is the regulation, the administrative agency is the LGU, then the LGU still has supervisory or administrative authority over the public service. The bill does not eliminate any power of the public, administrative agency over the public service or public utility. The public utility provision or proposal is only classifying four services that are public utilities. It's water and electricity. Now, that does not mean that the rest will not be regulated anymore. They will still be regulated. If you are regulated by LTFRB, by CAB, by ERC, then the regulation stays. Marina or PPA, regulation stays. We have, just to make sure that it's on record, that the proposal only defines what's public utility. It does not do away with the powers of the administrative agency over the public utility or public service. Mr. Speaker.
well, Mr. Speaker, distinguished sponsor, nabanggit niyo rin doon sa inyong explanatory note that this will promote fair competition. The point that I'm driving at, Mr. Speaker, distinguished sponsor, if we allow all these big foreign corporations to manage, operate, and own our big utilities or companies that are vital to the Philippine economy, then nasan ho yung fair competition doon? If they can easily drop down their charges or their prices to be able to compete against a local company, then it defeats the purpose, distinguished sponsor, Mr. Speaker, the real essence of fair competition because these guys are too big. They're too big to compete with their local counterparts. Kaya nga siguro, yung framers ng ating Constitution contemplated that they should only be limited to 40% ownership kasi otherwise, kung sila yung nagko-control, maaaring wala nang pupuntahan yung ating mga industriya na ang may pagmamayari ay ang mga Pilipino. But I don't like to belabor that point anymore, Mr. Speaker, distinguished sponsor. One last point that I'd like to ask the distinguished sponsor is yung, we go now to the underlying purpose or justification of this measure, yung sinasabing to attract foreign direct investments. Will you agree with me, distinguished sponsor, that there are a number of factors other than what you have mentioned to attract foreign direct investments?
Yes, Mr. Speaker, that would be infrastructure, the incentives that we give, cost of labor, so many factors that in which I think our current administration is working on simultaneously, Mr. Speaker.
Thank you, Mr. Speaker, for that information. But I do believe, distinguished sponsor, that opening up the economy does not entail changing the real definition of public utility if only the objective is to attract foreign direct investments. Kasi ang sinasabi ho ng mga statistics, hindi naman ho yung batas na redefining what is public utility that will attract them to come to our country. Sinasabi ko dito, wage rates, labor skills, tax rates, transportation and infrastructure, the size of the economy are the factors that the investors are looking for before they invest. In fact, meron din hong table na nagpapakita na yung number one sa investment decisions of a company before they make investments in another country are yung number one po, yung tax rates and ease of tax payments. Number two, technological and innovation capabilities. Number three, general security and environment. Number four, regulatory transparency and lack of corruption. Number five, strength of investor and property rights, and so on and so forth. Nowhere in all these statistics that would show that opening up or redefining the public utility definition would open up the interest of foreign direct investors to come to our country. Wala ho yun. Hindi ho nila iniisip yun. In fact, even in Singapore, where we sometimes use as a model, ay ang number one ho nila doon ay financial and insurance services. Ang number two po nila na rason for investments ng FDIs nila ay wholesale and retail trade. So, in saying that, Mr. Speaker, my distinguished colleague, I'd just like to emphasize a point na hindi siguro kinakailangan buksan ang ating definition or palitan ng definition ng public utility in order to attract foreign direct investments. Even in China, where they said the construction and operation of airports, transportation is relatively controlled by the Chinese government. Even in Vietnam, where they have a slightly higher percentage of FDIs compared to the Philippines, sinasabi rin ho nila doon, meron ng conditional restrictions. Hindi ho nila inopen yung transportation, hindi ho nila inopen yung telecommunications for foreign control. So, if the justification of the passing of this proposed measure would, say the least, attract investors, I strongly disagree with that idea, Mr. Speaker, my distinguished colleague.
Mr. Speaker, according to the NEDA, Philippine Development Plan, amending the PSA, the Public Service Act, this bill we are proposing today, is crucial to expanding economic opportunities and increasing the competitiveness of the Philippines. In fact, right now, we are slowing down in terms of foreign direct investments because we are one of the most restrictive economies in the world, and probably the most in our region in terms of foreign direct investments. What is the advantage of having foreign direct investments? Because our basic services, our public services, specifically transportation, telecommunications, whether air transport, sea transport, and land transport, are very expensive and the service is poor. If you have competition, you need more players. And we are on a plateau right now. We cannot extract more investments from our fellow Filipinos. Should there be more Filipinos that were willing to invest or have the capital, big capital for such things as telecommunications businesses, then they would they would be delivering better services to our countrymen. But there are none anymore, Mr. Speaker. It is not because the protectionist idea of our Constitution is not because we don't want foreign investments. We want foreign investment to supplement the Filipino capital. Kasi kailangan ng tulong din ang Pilipino para makapagpatayo tayo ng malalaking industriya, malalaking negosyo, so that we can improve the basic services to the Filipinos. In fact, before, when we only had PLDT, we had so many problems. Tapos pumasok ang Globe at Smart. Nung pumasok ang Sun at nag-offer ng unli calls and unli texts, the rates improved and the services improved. In the same way that there was only PAL and Cebu Pacific, Tiger Air, and Asia Pacific came in, the rates improved and the services improved. Now, we have a problem with sea transport. We need more investors in sea transport because the service is bad and the cost is too high. If our Philippine capital or investors cannot afford to do such investment, then we need to supplement that with foreign direct investments. Hence, I do not believe that this will be a threat to our patrimony or a threat to our protectionist idea based on our Constitution. I think this will improve the lives of all Filipinos. Hindi lang po to na dahil po we are taking away the businesses from other Filipinos. It is not because we are granting more opportunities for foreigners. It is the point here is to improve the services to the Filipinos, whether it be transportation, whether it be telecommunications, our internet, which is the slowest in the world. Hopefully, it can be improved because they'll bring in the investment as well as the technology, so that we can help our fellow Filipinos in order to improve their lives by improving the basic services, Mr. Speaker.
So essentially, Mr. Speaker, distinguished sponsor, you're saying that we should pass this law in order to let these investors come so that we can provide better services to our Filipinos. Is that correct to assume?
That's one of the reasons, Mr. Speaker.
Okay. Following your line of thinking, Mr. Speaker, my distinguished colleague, it clearly, if the justification of passing this proposed measure into law is only to attract investments, clearly it will not address the interest of the foreign corporations to come to us if we pass this law. Because according to them, there are other factors why they will invest in our country. And none of those, in the lists of all the reasons why they invest in a foreign country and factors that they use as basis for their investment, it does not say about redefining the meaning of public utility. Mr. Speaker, distinguished colleague, I do agree with you that there is really a need to help this government to attract investments. But perhaps we are training our crosshairs in a different target. We should, based on our studies, address the issue of wage rates, labor skills, tax rates, transport and infrastructure, the ease of doing business, the cost of electricity. Doon tayo dapat nakafocus.
Mr. Speaker, I agree. We have to improve our tax rates, we have to improve our incentives, we have to improve our labor force, train them better, we have to improve our infrastructure, but at the same time, we have to allow foreigners to invest in some, not in all, in some of the industries. Now, for example, if we focus on telecommunications or even transportation, that would require, if not hundreds, millions or billions of dollars. With the constitutional limitation on 40/60, there is a constitutional limitation in classifying an industry as a public utility. It says, no franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines. Right? But the latter part of this section, the participation of foreign investors in the governing body of any public utility enterprise shall be limited to their proportionate share in its capital. And all the executive and managing officers of such corporation or association must be citizens of the Philippines. Now, if you want them to invest billions of dollars or millions of dollars, then what kind of company or foreign company would invest millions and billions of dollars if they do not have control over the management of such industry? Now, this will liberalize, yes, it will liberalize some industries in our country, but it will also be a fair treatment for all those who are helping our country in improving the services for the Filipino people. Kaya, there is a need to open up some industries, not all, because some of them have to be protected because of national security or national interest, but some have to be opened because we have an outdated law which was crafted back in 1936, Mr. Speaker.
Thank you, distinguished sponsor, for that enlightenment. However, this representation would like to stress the point that, yes, I certainly and absolutely agree with you that there is really a need to open up our economy. Ako po ay sumasang-ayon dyan. Ngunit, hindi lamang po sa mga public utilities as defined, as contemplated by the framers of our Constitution, and as decided, as stipulated in the jurisprudence of our courts. Yun lang po ang akin, Mr. Speaker, distinguished sponsor. Kasi nga ho, we might be shooting ourselves in the foot. Kapag ka inopen mo yan, naging kompetensya niya ng ating mga lokal na mga negosyante, maaaring hindi tayo makalaban sa kompetisyon. Mr. Speaker, distinguished sponsor. Well, I've discussed enough already, and with the winking of the eye of the distinguished sponsor, it seems that she's sending me a signal that she wants me to stop. And,
Yes, please.
Mr. Speaker, distinguished sponsor, thank you for your clarifications. And at the appropriate time, this representation would propose amendments to the proposed measure if the distinguished sponsor would agree.
We will take it into consideration, Mr. Speaker. Thank you very much.
Thank you very much, Mr. Speaker. Thank you very much, distinguished sponsor.
Majority Leader.
Mr. Speaker, I move we suspend consideration of House Bill number 78. I so move, Mr. Speaker.
Is there any objection? The chair is none. The motion is approved.
Mr. Speaker, I move we suspend until 3 p.m. Monday.
Adjourn.
Okay. I withdraw my motion. Mr. Speaker, I also move that we include additional co-authors to House Joint Resolution 19 as contained in the list to be submitted by the Committee on Rules. I so move, Mr. Speaker.
Is there any objection? The chair is none. The motion is approved. Majority Leader.
Kit. Move to suspend sessions.
Session suspended. Kalaban. Lakas ba si Kobe? Galing. Kaya man natin yan. Session resumed.
Mr. Speaker, we move to recognize Senior Deputy Minority Leader Janet Garin for the election of members of the different committees for the minority.
Honorable Green is hereby recognized.
Thank you, Mr. Speaker. Mr. Speaker, on behalf of the minority, I move that we elect the following members as additional members to the Committee on Aquaculture and Fisheries Resources: the Honorable Colyamat and the Honorable Bordado. Further, Mr. Speaker, for the Committee on Banks and Financial Intermediaries, I move that we elect a senior member to the said committee, the Honorable Stella Kimbo, and as additional members, the Honorable Sarah Jane Elago and the Honorable Law Fortune. For the Committee on Civil Service and Professional Regulation, I move that we elect a senior member, the Honorable Gabriel Bordado Jr., and as members, the Honorable Ferdinand Gaite and the Honorable Franz Castro. For the Committee on Cooperatives Development, Mr. Speaker, I move that we elect the Honorable Godofredo Guya as senior member and as additional member, the Honorable Dagook. For the Committee on Disaster Management, I move that we elect a senior member representing the minority, the Honorable Angelica Natasha Ko, and as additional member, the Honorable Arlene Brosas. For the Committee on Ecology, Mr. Speaker, we move that we elect a senior member to the Committee on Ecology, the Honorable Lawrence Fortune. For the Committee on Economic Affairs, we move that we elect a senior member, the Honorable Stella Luz Kimbo, and as additional members, the Honorable Franz Castro and the Honorable Nika Ko. For the Committee on Energy, as additional members, the Honorable Stella Kimbo and the Honorable Sarah Jane Elago. For the Committee on Foreign Affairs, as additional members, the Honorable Arnie Teves and the Honorable Sergio de Gook. For the Committee on Housing and Urban Development, as additional member, the Honorable Colyamat. The Honorable, for the Committee on Trade and Industry, as additional member, the Honorable Stella Kimbo. And for the Committee on Human Rights, I move that on behalf of the minority, we withdraw the membership of the Honorable Maria Victoria Umali and the Honorable Stella Luz Kimbo. For the Committee on Interparliamentary Relations and Diplomacy, in lieu of the Honorable Stella Luz Kimbo, on behalf of the minority, we move to elect the Honorable Lawrence Fortune. For the Committee on National Defense and Security, I move that we withdraw the nomination or the election of the Honorable Isagani Amatong, the Honorable Joseph Stephen Paduano, and the Honorable Kit Belmonte. For the Committee on Good Government and Public Accountability, I move that we withdraw the election of the Honorable Fernando Bayani and the Honorable Carabs Paduano as members representing the minority. So moved, Mr. Speaker.
Is there any objection? The chair is none. The motion is approved. Majority Leader.
Mr. Speaker, I move that we suspend session.
Session suspended.
Ready?
Session resumed.
Mr. Speaker, earlier we referred House Bill number 4749 to the Committee on Labor and Employment. I move that we change the referral of the House Bill number 4749 from the Committee on Labor and Employment to the Committee on Overseas Workers' Affairs. I so move, Mr. Speaker.
Is there any objection? The chair is none. The motion is approved. Majority Leader.
Furthermore, Mr. Speaker, may we inform the members that we have already distributed copies of Joint House Bill number 19 as joint resolution, which we earlier approved on second reading, just for the information of the body, Mr. Speaker.
Is there any objection? The chair is none. The motion is approved. Majority
Mr.
Leader.
Speaker, I move we suspend sessions until 3 p.m. on Monday. I so move, Mr. Speaker.
Session suspended till September 30, 3 p.m. 2019. Majority Leader, goodbye.
Goodbye, Ferdy.
Gumagana si Mike. Okay. 30 nga, September 30.